In this video, I'm going to discuss some historical Supreme Court decisions that illustrate a very long history of justices being results-oriented. And those results have been, for most of the Supreme Court's history, deeply reactionary, which will become apparent as I briefly discuss the results in some of those cases. I will include citations to the Supreme Court decisions that I'm about to discuss in the More section below. While I do believe the 6 Republican justices that we now have will reinstate the 1904 decision in Lochner that held that a state statute prescribing maximum work hours for bakers was unconstitutional, and that was a maximum of 10 hours per day, 60 hours per week. They are, in my opinion, every bit as reactionary and results-oriented as the majority in that case. A long history of results-oriented decisions starting in 1895 through 1936 is called the Lochner era of Supreme Court decisions. During that era, the Supreme Court found laws unconstitutional, for example, that regulated child labor or required minimum wages for children. The court also struck down some New Deal legislation as unconstitutional. A central theme throughout that era was the creation of a freedom to contract that existed that could not be meddled with by state or local governments in any way, which is a right that's not found in the Constitution. It was just created by the Supreme Court justices. So if a company wanted to pay a child 10 cents per hour and work them 60 hours or more per week, that was just fine with the Supreme Court. And it would be unconstitutional for a state or federal government to legislate on the matter. Any law relating to minimum wage, overtime, working conditions, and similar laws were viewed by the Supreme Court as unconstitutional. When FDR threatened to increase the number of justices in response to those kind of decisions, one of the justices had a change of heart, and that is referred to as a switch in time saves 9. Included in the obvious results-oriented Supreme Court decisions is the 8-1 1896 decision in Plessy v. Ferguson, where the Supreme Court held that separate but equal was constitutional, meaning segregation of the races on all matters was constitutional, but it was never equal, of course, and the justices knew it when they decided that case. I am old enough to remember a water fountain at a Little League ballpark in Nashville that had a sign saying whites only, and lunch counters in downtown Nashville being segregated by race. The Lochner era was preceded by decisions like the 1857 Dred Scott decision, where the Supreme Court of the United States decided that Black Americans were not entitled to American citizenship, even if they were born in the United States, which Congress tried to rectify after the Civil War with the passage of the 14th Amendment. When Congress tried to implement legislation to protect the civil rights of newly freed slaves during the Reconstruction period, believing that the 14th Amendment gave them this authority, Supreme Court found that those laws, known as the Civil Rights Act of 1875, were unconstitutional. It took almost 100 years before Congress was able to pass the Civil Rights Act of 1964 and 1965, and the Republican justices recently struck down part of that act relating to voting rights in Shelby County v. Holder. Yet during the same period that the Supreme Court found civil rights laws unconstitutional, the Supreme Court found that the 14th Amendment protected corporations since they came within the definition of a person. This is a judge-created policy rule that ignores the plain meaning of person, which is of course, a human being, not an entity. And all Supreme Court decisions granting constitutional rights thereafter, including the Citizens United case, are results-oriented decisions that carry on this policy decision that was made in the late 19th century that corporations were persons under the 14th Amendment. Is that the correct policy decision to grant constitutional rights to corporations? I would say yes, but to do so requires a results-oriented Supreme Court, which is what we've had for most of our history. To sum up the line of cases that I just briefly discussed, the 14th Amendment provided constitutional rights to corporations as persons, but civil rights laws passed during Reconstruction to protect former slaves and was passed pursuant to that amendment were held to be unconstitutional, notwithstanding the 14th Amendment being clearly intended to protect the former slaves. The current Republican justices are as much result-oriented as their kindred spirits in the 1850 to 1937 period. Results-oriented decisions include the recent Fisher decision that ignored the plain meaning and textualist judicial interpretation standards to basically rewrite the obstruction of an official proceeding criminal statute. The creation of out of whole cloth, a presidential immunity from criminal prosecution, which could not be described as conservative by anyone who actually is a conservative. When the Constitution actually imposes a duty on the president to see that the laws are faithfully executed. All of the corporation is a person to entitled corporate rights is entitled to corporate rights decisions, including Citizens United. And I would add, ignoring their claimed originalist plain meaning and textualist interpretation judicial standards when they incorporated the Second Amendment into the Due Process Clause of the 14th Amendment, which simply states the following, quote, "Nor shall any state deprive any person of life, liberty, or property without due process of law," end quote. That's all it says. There's no incorporation language in that phrase. When incorporating the Second Amendment into the Due Process Clause to strike down a state gun law, the Republican justices acknowledged that John Marshall, the first Chief Justice and a contemporary of the founders, wrote an opinion that held that the founders did not intend the Bill of Rights to apply to state action at all, and only to federal laws. So how do the originalists, or the people that claim to be originalists who are Republicans on the Supreme Court, do a workaround to strike down a state gun law with this kind of decision by the first Chief Justice who knew what the founders intended and said so clearly in the Barron decision? The workaround for the Republican justices who claim to be originalists when it suits them is to incorporate the Second Amendment into the Due Process Clause of the 14th Amendment, which contains no language of incorporation and would be understood by lawyers when it was passed in 1868 and now as a procedural provision that persons have a right to be heard before life, liberty, and property is deprived. The incorporation of the Bill of Rights into the 14th Amendment is a good policy. It creates uniformity of constitutional rights and prevents states from violating the constitutional rights contained in the Bill of Rights, which many would do. However, incorporation is still a judge-created, results-oriented approach that has no support textually or in the plain meaning judicial interpretation standards, and virtually no support in the legislative history other than short statements made by one congressman, his name was Bingham, and one senator, his name was Howard. Bingham's statement was ambiguous according to some legal scholars. It would have been a simple matter for those who drafted the 14th Amendment to include corporation language if that was actually the intent. And for justices who, and the Republican justices who claim to be originalists, and that is just a claim, it is imperative to ignore a Supreme Court decision about 1 year after the 14th Amendment was adopted. You would think the 9 Supreme Court justices would know whether anything from the Bill of Rights was incorporated into the 14th Amendment 1 year after it was passed. A unanimous Supreme Court held in the 1869 Twitchell decision that the application of the Fifth and Sixth Amendments to the states was, quote, no longer a subject of discussion, end quote, citing the Barron's decision by Chief Justice Marshall. The 9 justices in this Twitchell decision in 1869 just did not understand that those amendments had been incorporated into the Due Process Clause, something that the Supreme Court justices first found in 1925 when they incorporated the First Amendment into the Due Process Clause and applied it to state action. If you're opposed to the 19th century ideology of the Republican justices, then the remedy is to never vote for a Republican politician again. It's only going to get a lot worse, particularly if Trump wins and Alito and Thomas retire and Trump appoints 2 more younger versions of these justices. I did mention that the first incorporation was the First Amendment in 1925. The Second Amendment was not found in the Due Process Clause until 2010. That's when the Republican justices found it.